Okay, so it's 1 o'clock. Let's get started. Thank you everyone for joining us today. My name is Diana Padierna, and I am the Executive Director at Landlord Self-Help Center. We are excited to present our last Landlord Lunch and Learn series webinar of the season. So I'll just go over some housekeeping reminders before we start. We are recording this webinar and it will be available on the Landlord Self-Help Center's website if you would like to rewatch. Also, the Q&A features enable for you to submit your questions pertaining to this webinar, and the questions will be addressed during our Q&A period at the end of the presentation. Our presenters will be answering only questions pertaining to this presentation. If you have any questions about your own situation, please contact our office during our business hours. Okay, so let's begin.
Hello and welcome to the Landlord Self-Help Center Landlord Lunch and Learn session. My name is Catherine and I'm a community legal worker and licensed paralegal. My colleague Ashley has helped me prepare this presentation today. We'll also be joined later on by the Rental Housing Enforcement Unit. The Landlord Self-Help Center is a community legal clinic funded by Legal Aid Ontario. The Landlord Self-Help Center was founded in 1975 and incorporated in 1977. We have a province-wide mandate to support small-scale landlords, and approximately 80% of the Landlord Self-Help Center's resources are dedicated to client services. This Landlord Lunch and Learn series is the final one for this year and will focus on evictions with the sheriff. As Diana mentioned, this presentation will be made available for replay on our website and YouTube channel, along with past presentations. Please note that this information offered in the presentation is intended as general information and is not legal advice. For our land acknowledgement, at the Landlord Self-Help Center, we acknowledge the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. We acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaty signed by multiple Mississaugas and Chippewa bands. As a community legal clinic funded by Legal Aid Ontario with a province-wide mandate, we acknowledge that there are 46 treaties and other agreements that cover the territory that is now called Ontario. And we make this acknowledgement in support of the necessary work of reconciliation. The Residential Tenancies Act was created in 2006 and is the Ontario legislation that governs most residential tenancies and matters relating to renting in Ontario. The Residential Tenancies Act is commonly referred to as the RTA. The RTA establishes laws for landlord and tenant obligations, rights, and responsibilities. It regulates rent, such as rent increases, and it also provides the tenant with security of tenancy and outlines the grounds of termination of tenancies. The Landlord Tenant Board. Under the Residential Tenancies Act, Section 168, subsection 2, states that the Landlord Tenant Board has exclusive jurisdiction to determine all applications under the Residential Tenancies Act and with respect to all matters in which jurisdiction is conferred on by the Residential Tenancies Act. As such, the Landlord Tenant Board is the only lawful way to obtain an order of eviction. In most cases, such as L1 applications, which are to evict a tenant for non-payment of rent, or L2 applications, which cover evictions for things like personal use or damages, the landlord and the tenant will go to a hearing in front of the Landlord Tenant Board. At the hearing, the tenant will be given a chance to dispute the eviction. In some cases, such as L3 applications, which is when the tenant gave notice or agreed to terminate the tenancy, or L4 applications, which is when the tenant failed to meet conditions of a settlement, the landlord can apply for an order for eviction ex parte. Ex parte means that the landlord-tenant board does not go to a hearing and decides the order in writing without the tenant's ability to defend the eviction. It is important to understand that a landlord cannot file for a sheriff eviction without an order from the landlord-tenant. As discussed earlier, the Residential Tenancies Act lays out grounds for eviction. Reasons a landlord can evict a tenant include if the tenant has not paid rent, if the tenant pays rent persistently late, if the landlord needs the unit for their own personal use, or the landlord sells the unit to a purchaser who wants it for their own use. If the tenant's behavior causes interference with others, damages to the property, serious safety concerns, or illegal activity. If the landlord wishes to demolish, repair, or convert the unit. If the person is an unauthorized occupant, meaning not a tenant on the lease agreement, or if the tenant gave notice or agreed to terminate the tenancy. Once you go to the hearing, your application will rather be successful for eviction or not. If your application is successful, you will receive the eviction order. On the screen, you will see an order retrieved from CanLII that is voidable. If your application was based on non-payment of rent, the order will be voidable, meaning that the tenant has the opportunity to cancel the eviction. It will include something like what you see on paragraph 2 that outlines that the tenant can pay the arrears by the eviction date and void the order. It will also include something like what you see in paragraph 3 that explains if the tenant pays the arrears and any rent that has come due after the termination date, but before the sheriff has evicted, the tenant can file a motion to stay the order. I'll talk more about motions and stays later in this presentation. Lastly, it will include something like paragraph 8 that provides the landlord with the date that they can apply for eviction with the sheriff. This will always be the day following the termination date. If your application was not based on rent arrears, the order will not be voidable. On the screen is an example of a non-voidable order, which I also retrieved from CanLII. In this case, it will outline the termination date and the date that you can file for the sheriff. So you'll see in this order, the termination date is October 31st, and the landlord can file for eviction with the sheriff on November 1st. So what happens next? There is no government body that records statistics about how many sheriff evictions are filed or how many sheriff evictions take place in the province. As such, it is hard to determine the probability of which scenario a landlord is likely to encounter with their eviction. However, it is important to note that after you receive the eviction order, a number of things might happen. The first being scenario 1, which is where the tenant vacates prior to or on the eviction date. In this case, there's no need to file for eviction with the sheriff. The landlord can take back possession of the rental unit. This is obviously the best case scenario for landlords. The second is if a tenant files a motion or review. If the tenant is successful with the motion or request to review, the eviction order is stayed. At that time, the landlord can not file for eviction with the sheriff. The last being scenario 3, which is if the tenant hasn't vacated by the termination date and the tenants have not voided the order by paying the arrears or have a stayed order because of a motion or review. This is when the landlord can file for eviction with the sheriff. Tenant motions and reviews. Tenants can file a motion for two reasons. The first is if they voided the eviction order by paying all of their arrears, even after the termination date. The second is if the decision for eviction was made ex parte. Tenants can review an order if there is a serious matter of fact or a serious error of law, or they were unable to participate. If the tenant files a motion, a hearing is automatically granted. If a tenant files a request for review, it will rather be granted or denied. If the request for review is granted, then there will be a hearing to determine the outcome of the eviction. If at the hearing, the tenant is successful with their motion or review, the eviction cannot take place and it will remain stayed. If the landlord has not yet filed the eviction order with the sheriff, they will not be able to do so. If the landlord has filed the eviction order with the sheriff, they may be able to recover the cost of filing that was associated with ordering the sheriff's eviction. Filing for eviction. On the screen, you'll see the eviction information requirements form. This needs to be filled out prior to filing for the eviction. You can see on the top of the page, there's a disclaimer stating that if the sheriff's office does not have this information, it may result in a delay of eviction. The form includes the address of the rental unit, including how you would access the rental unit. It also includes the landlord's information, along with the contact information of the person who will be responsible for the eviction. As well, there's additional information about who occupies the unit, such as children or if there are any pets. Lastly, there is a section which asks about the tenant, such as criminal history or mobility issues. It is important to note that this form is not available on the landlord tenant's website. To access this form, please find it online at ontariocourtforms.on.ca/en/eviction-forms or obtain a copy at your local sheriff's office.
Where to file. You must take 2 certified copies of the Landlord and Tenant Board order to the Court Enforcement Office, also known as the Sheriff's Office. A certified copy means a copy with the red endorsement included. You can print this off by selecting Document and Markups in the Print Option dialog box of a PDF document. This will ensure that the stamp is visible when printed. You must file with the sheriff who has territorial jurisdiction where the rental unit is located. The sheriff is generally located in local Ontario Court of Justice locations. Currently, you cannot file online for sheriff enforcement. You can only file in person or by mail. A list of all the court locations can be found online at ontario.ca/locations/courts. The Landlord Self-Help Center advises calling your local sheriff's office prior to filing, as different offices may have different practices and procedures.
The cost of enforcing an eviction. There is a cost associated with filing for the sheriff. There is a $75 filing fee and a $240 enforcement fee. There is also a travel allowance, which is calculated at 30 cents per kilometer for Southern Ontario or 35 cents per kilometer for Northern Ontario. You will have to pay this fee at the time of filing, which can be paid in person via credit card, check, or debit, or by mail being via certified check.
Notice to vacate. The sheriff will send out a notice to vacate to the tenant. You can call your local sheriff's office to confirm how the notice will be sent to your tenant. Each jurisdiction has its own sheriff's office, and each office may have slightly different processes and procedures. The notice to vacate will instruct the tenant to vacate by a certain date. Generally, a notice to vacate is sent out 10 days before enforcement. The notice to vacate will include the reason for enforcement. It will list whether it is by virtue of a landlord and tenant board or superior court order for vacant possession. A notice to vacate will also include the names of the landlord and tenant. It will include the address of the rental unit, and it will include the date the order will be carried out if the tenant fails to vacate. Changing locks. The landlord or landlord's agent must be in attendance at the property in order to accept vacant possession after sheriff enforcement. The landlord or landlord's agent should be prepared to change the locks. The sheriff is not responsible to change the locks of the rental unit. The landlord should be prepared to do this or have someone, such as a locksmith, do it on the date of sheriff enforcement. Tenant belongings. Once an eviction has taken place and the locks are changed, the tenant has 72 hours to arrange for the collection of their belongings. Since the time for retrieval under the law is between 8 a.m. and 8 p.m., best practice would be to coordinate pickup times with the tenant throughout the course of 72 hours following the eviction. What happens after 72 hours? The landlord is legally allowed to sell, keep, or dispose of the belongings if the tenant fails to retrieve them during the 72-hour collection period. Landlords who do not make the tenant's belongings available for collection during the 72-hour period, or who dispose of the items before the 72-hour period is over, may be subject to a complaint with the Rental Housing Enforcement Unit and/or an application at the Landlord-Tenant Board. A tenant may file a T2 tenant rights application if the landlord does not make the belongings available for collection during the 72-hour period. Collecting. The sheriff does not enforce the collection of arrears or other monies owed to a landlord. For further information, you can visit our collections garnishment fact sheet on our website. Our website is landlordselfhelp.com. You can view our fact sheets by visiting landlordselfhelp.com/RTA-fact-sheets. Resources. Landlord Self-Help Center. Our website is landlordselfhelp.com. We currently have RTA fact sheets, sound advice podcast, landlord learning modules, frequently asked questions. We have information on a variety of topics for landlords to listen, read, and learn. You can also follow us on Facebook at facebook.com/landlordselfhelp. We also now have an Instagram. You can follow us at landlordselfhelp or by going to instagram.com/landlordselfhelp. We do also maintain a YouTube channel. You can find us on YouTube at Landlord's Self-Help Center 7429. Resources. The Landlord and Tenant Board also has a website available. You can visit the Landlord and Tenant Board at tribunalsontario.ca. They have practice directions, interpretation guidelines, and navigating Tribunals Ontario. If you're looking to hire a legal representative, you can also visit the Law Society Referral Service. Their website is findlegalhelp.ca.
That concludes the Landlord Self-Help Center portion of the presentation. Before we move on to the Q&A period, I would like to introduce Suzette Carr, who is a manager with the Rental Housing Enforcement Unit.
Thank you so much for having me. I'm having some technical difficulties today, so my apologies. Thank you for inviting us to attend this session. Some of the information you already discussed was actually some things that I plan to speak about during this session. So I think I'll just jump right into what happens if a tenant calls the Rental Housing Enforcement Unit to complain about this issue. So as previously covered, I'm certain prior to me joining the session, you discussed the offense of the landlord failing to provide the tenant with 72 hours access. That is an offense under the Residential Tenancies Act, and that is under Section 234B of the Act. There are various sections throughout the Act and also in the regulations that discuss matters such as disposal of the abandoned property where the eviction order was enforced, and that's specifically under the regulations 51606, and also Section 46 speaks to the hours for retrieving the property, as I just heard mentioned as well. So I'll jump right into it. In our unit, if you are not aware, we receive complaints from residential landlords and tenants alleging that offenses have been committed under the Residential Tenancies Act. We have the jurisdiction to monitor compliance with that section of the Act. And today I'm here to speak specifically about this offense of the landlord failing to provide the 72 hours access. In our unit, we are going to look at a number of things first, which is whether or not the landlord and tenant relationships exist. That seems pretty basic, but you'd be surprised. We want to make sure that an eviction order was issued by the Landlord and Tenant Board. We also want to ensure that it was enforced by the sheriff. Advice to landlords is not to take matters into your own hands. Just because the Landlord and Tenant Board has issued an order giving you vacant possession of, the right to recover possession of that unit, it can only be enforced by the sheriff. So make sure you do that. You go to the sheriff. I just heard the instructions about how to do that and what the filing fees are. So make sure you do that. The tenant also has to have attempted to retrieve his or her property, and the landlord would be alleged to have prevented them from doing so, and that's the reason why they would call our unit. As a note, as you've just heard prior, a landlord shall make an evicted tenant's property available to be retrieved at a location close to the rental unit during the prescribed hours within the 72 hours after the enforcement of the order. As you just heard, that's between 8 a.m. and 8 p.m. So for example, if an eviction order is enforced at 4 p.m. on Friday, the tenant's property may be retrieved from 4 p.m. to 8 p.m. on Friday, 8 p.m. to 8 p.m. on Saturday and Sunday, and 8 a.m. to 4 p.m. on Monday. And after that point, there are situations where landlords and tenants try to broker their own deal, and that is something completely different. Once the complaint is filed with our unit, our compliance officer who does the intake will contact the landlord and discuss the issue. In most cases, we will also contact the sheriff to confirm that the order was indeed enforced by them. We will then contact the landlord and discuss the complaint and say, your tenant X contacted us, indicated that the landlord and tenant board eviction order had been enforced, but you were preventing them from getting access to their belongings. We will tell the landlord the tenant side, and we will also get the landlord's information, their version of the detail of the events that occurred. From there, we will send the landlord what we call an intervention letter, which is basically an information piece to educate the landlord about their rights and responsibilities under the act where it comes to this offense. It would also list the penalties provided for non-compliance and give the landlord all the information. We will then check in with the tenant again to see whether or not the landlord had complied with the instructions or the suggestion of the compliance officer. Most cases, the landlord does comply. They do allow the tenant to get access to the unit and to their belongings. We can go ahead and close the file as successful compliance. That's a happy path. We really, hope that happens in every complaint that is filed with our unit. Where that does not happen, and we try to get compliance, if we are unsuccessful in getting compliance, meaning the landlord does not agree to allow access to that tenant, we would then refer that matter on for further consideration. And further consideration means that the investigation coordinator would have a look at the file and see whether or not we think we have enough information to further investigate this complaint. An investigator would then take that over and would go into gather as much evidence as possible to see whether or not that supports a prosecution or could support a prosecution. They would meet with the tenant to get a statement and gather all the other evidence. The tenant may have said, oh, I've contacted my landlord and I tried to make arrangements. Here are my text messages, here are my emails, here are my phone records. A number of things could have happened. We may contact a number of individuals or companies to confirm the tenant story before, recommending to our Crown Counsel that we have enough information to lay charges in provincial offences court. If that is done, then we would begin our prosecution activities, and that would go on to provincial offences court. That is obviously the worst case scenario. We do not want that to happen. We want everyone to comply with the legislation. And we want everybody to walk away, feeling as though their rights have been protected. So in some situations, for example, I'll give you some scenarios that of complaints that come into our unit against, where tenants complain against the landlords about this particular offense. So the tenant complains that they're trying to contact the landlord to retrieve their belongings, but the landlord is either unavailable or doesn't return the calls. In that scenario, we are going to take the complaint. That 72-hour access time is ticking away in the background. We are going to confirm the time of the enforcement of the order, when the eviction occurred, and figure out when that 72-hour access period expires. There are situations, in this situation, we would educate the landlord about the tenant's access rights under the Residential Tenancies Act. Another situation, restricting or limiting the time that the tenant can retrieve their belongings. Sometimes landlords say, you know what, you can come from 1 until 2 o'clock on day 1, 2 until 3 on day 2, and you can't come on day 3. We don't like that. When that happens, the landlord restricts their time. We would basically inform the landlord that they need to be available so the tenant can move out their belongings. So in other words, be reasonable. We also are not advocating for the tenant to have 12-hour access windows every single day, but we are saying be reasonable. An hour to retrieve their belongings may not be sufficient time for them to do that. We do understand that there was quite a bit of notice leading up to the enforcement of this order. So, there was a landlord and tenant board hearing. Yes, we are aware of that. There was an order that was issued, also giving some other timelines about when this eviction could take place if the conditions of that order are not met. The sheriff will also give some sort of notice saying that they will be enforcing the order. So we understand the tenant had quite some time to do that, and we understand the frustration from the landlord's perspective. However, the tenants legislatively do have this time to retrieve their belongings. So we want to make sure that they're able to do that. We received complaints of the tenant. They started moving out, but they ran out of time, and the landlord won't let them go back in to finish moving. If they did not do their due diligence, if they did not, if they went on the last day and tried to start moving the last hour, that's something we may not consider doing an intake on, because the tenant did not make their best efforts to use that time wisely to collect their belongings. Some tenants indicate while they were out of town when the sheriff came and enforced the order. We're also not going to be looking into that. That time period is very specific. So some of the options that are available to the tenants, if they contact us, they can also go to the landlord and tenant board and file an application against landlords because they were not afforded that right to retrieve their belongings during that time. And so as I said, landlords, just make sure that you are completely aware of your rights and responsibilities as it comes to this part of the eviction process. The landlord and tenant board has really good resources on their site as well. And these resources include information about what to do when let me tell you the exact name. What to do when an eviction occurs. I don't have the exact name. Let me see if I can find that for you. There is a really good brochure at the landlord and tenant board, and it's called Property Left Behind When a Tenant Moves Out. And it really speaks to landlords, what your right is to, and I heard mentioned when I joined this meeting about your right to accessing their belongings, so the right to sell, dispose of any property left behind after the enforcement of this eviction order. So you may want to take a look at that brochure and be familiar with what the rules and regulations are about that. So subject to any more questions anyone may have.
Thank you, Suzette. So I guess, yeah, we can open up the floor for our Q&A period. Okay, so we received a question, and this is for the rental house enforcement unit. So what happens if the landlord changes the locks prior to the sheriff coming to the property?
So we never encourage that to happen. As I said, once the eviction order is issued, you're almost at the finish line. Just see the process through all the way and follow the rules. If the landlord decides to change the locks prior to the sheriff enforcing the order, then the tenant can file a complaint with our unit about altering the locks. And we are going to contact the landlord and go through that process of altering the locks. You're not allowed to, that's also another offense under the act, altering the locks unlawfully. So
Thank you. Okay, we're going to go through some of the questions that came to us during the presentation. So the first question says, what do you mean can be retrieved from Canley? I think that was mentioned during your presentation, Catherine.
Yeah, so if people aren't aware, oftentimes courts and tribunals will release their decisions on a Canadian-wide database. So you can find it online at www.canley.org. So when I had said that I had retrieved these different orders on Canley, I just went on to the database that's available. I searched Ontario, searched the Landlord Tenant Board Tribunal, and found them that way. So it's a public record for anybody who's interested in seeing what the tribunal issued for other people's matters. Sorry, I
Thank you.
should note too that not every single landlord tenant board decision is published on Canly, but a good amount of them are.
Thank you, Catherine. Another question says the following. You said that if the tenant leaves, then you don't need to file with the sheriff. What happens when the tenant leaves, the landlord enters and changes the logs, but the tenant stays, says that they haven't moved out yet?
Um, I mean, it's whether the tenant has moved out or the tenant hasn't moved out. So if you find yourself in a situation where you have an eviction order and you don't, that you don't think the tenant has actually left, I'd recommend calling our office for further clarification or seeking other legal help.
Okay, I'll read a question for Suzette. What if the tenant lies about not having access to get their stuff?
So we perform our work mostly over the telephone. We're going to ask them information. We don't automatically just believe one side of the story without checking in on the other side. So we're going to do our own fact finding to figure out um, it can be show me your phone records, speak to the landlord. The landlord may at that point disagree with what the tenant is saying and offer up a time, and we try to negotiate a time for both of them to meet at the property. We can usually tell who's not being honest about that. But we certainly, as I said, we don't just go ahead and immediately charge individuals with committing an offense. We do our due diligence to figure out, what the facts are and whether or not the complaint is supported.
Thank you. Somebody else is asking, what does exactly the sheriff do? Does the furniture stay in the house or is it removed from the house? Yes, you can answer that, Catherine.
Yeah, it's not the sheriff's responsibility to remove any of the tenant's belongings. So you're going to, after that 72-hour period has lapsed, you will be responsible for removing anything that is still in the unit.
Thank you. Somebody else is asking, does vacating prior to the eviction by the tenant mean handing in the keys to the landlord only? Catherine?
Again, I mean, lots of different things can happen. You really need to use a test of reasonableness. If the tenant has given you the keys, obviously they're leaving. If the tenant leaves the keys, somewhere in the rental unit and the door unlocked, technically they've left. Again, because these situations can vary so much. If you have a question about, if your tenant is still in the unit or hasn't actually vacated, you can give us a call or seek legal advice elsewhere.
Thank you. So we have two attendees asking about the 72 hours. So these questions will go to Suzette. Somebody's asking to calculate 72 hours, 12 hours per day is eligible hours out of 24 hours. And somebody else is asking, what are the exact time frames for the 72 hours? Is it something we set ourselves as landlords?
Yeah, so the regulations state that the access should be between 8 a.m. and 8 p.m. So we're not asking, landlords to make themselves available at 6 in the morning or, 10 at night to allow the access. So it's between 8 and 8 for those days following the enforcement of the eviction order. So that is just the window that they have to use. So as I said before, just be reasonable, be completely reasonable with allowing access to the belongings. If you think that between 4 and 8, for 3 days is what's agreeable to two of you. I don't personally love, I'm sorry, I know the sheriff's on the call. I don't love a Friday eviction. I find that on the weekends is when things can go a bit crazy, although it sounds like it'll be a lot of time available for the tenants to retrieve their belongings, but sometimes that there's no one is available for you to call during that time. If you run into issues, besides the police may intervene in some cases and assist the landlords and tenants during this process. But the bottom line is being reasonable. There is no set, and the act does not say you must be there from 12 to 4 daily. It says that they're allowed to, make it available for them to retrieve between the hours of 8 a.m. to 8 p.m. So it's up to the landlord, it's up to you, the landlord, and the tenant to do what is reasonable during that time. If a tenant is renting a bachelor apartment, it's not going to take as much time and probably not require as much access if you're renting out a single family home that is 3 bedrooms, a basement, a main floor. That's going to take a bit more time for the tenant perhaps to pack up and to get their moving truck and to remove their belongings from the unit. So again, it's just being reasonable. Do we need to book an elevator? Do we need to, there's so many things that come into play here, and it's just hoping that landlords and tenants can come to an agreement when it comes to this.
What if the tenant has a disability?
Is that question for me or for?
Yes.
There's nothing in the act that speaks to that issue. If the tenant needs some supports in helping, I would suggest that tenant needs to contact the appropriate resources to provide them with assistance. But there's nothing in the act that speaks to special circumstances to allow for additional times to retrieve or to remove their belongings from the unit. I'll leave the rest to Catherine, I think.
Thank
Yeah,
you.
thanks, Suzette. Just to add on to that, it is one of the questions on the eviction request information form that you have to fill out with the sheriff. As far as I know, the sheriff doesn't, I'm not exactly sure what they do in that situation. So if you do ever find yourself where you have tenants who have mobility issues who are going to potentially be getting evicted by the sheriff, I would recommend calling that individual sheriff's office beforehand to see if there's any onus on you as a landlord in terms of accommodations under the human rights.
Thank you. Somebody else is asking, the tenant receives an order of eviction. However, the tenant still asks for me to interfere with issues that he has with other tenants upstairs. Legally, do I have to respond to him? At this point, the tenant is a squatter. Catherine?
Yeah, so maybe this is going to be an unpopular answer, but I would always urge landlords to continue carrying out their landlord obligations up to the point that the sheriff has enforced the eviction.
Thank you. Somebody is asking, I see that one of the reasons for eviction is an unauthorized tenant, name not on the lease. How about when your tenant is subletting to others? In that case, landlords do not have those names on the lease.
So as it was stated in the presentation, an unauthorized occupant gives the landlord a valid reason to file for eviction with the landlord tenant board. So in this case, there is an A2 application that deals specifically with unauthorized occupants. So if it's a subletter not leaving or some other situation, the landlord would have to file an A2 application, which would then grant them, if successful, an eviction order for the people who are considered unauthorized occupants.
Thank you.
If I can just add to that, when the sheriff is enforcing the order, they're not enforcing against a person, they're recovering possession of a unit. So even if you don't know, you would, as Catherine mentioned, go through the process of filing the application. But once that eviction order is issued, it's to get possession of the unit. If a person's name is spelled incorrectly, those sorts of things, it's not going to make a difference. It's getting possession of that unit.
Thank you. Somebody's asking, could you walk us through what happens when the sheriff arrives and find the tenants are still there? What are their next steps? Catherine?
Yeah. So essentially, when you get the notice that the sheriff is coming, it's your obligation to change the locks, and it's the sheriff's obligation to provide the landlord with vacant possession. So they will forcefully remove anybody who is still in the unit. And there's paperwork that needs to be done that basically will provide the landlord with a certificate of vacant possession. If you have any specific questions, because the sheriff's office are jurisdictional, I would highly recommend calling them prior, or again, calling our office or seeking other legal advice.
Thank you. One of the previous questions that we received was pertaining to how long does it take for the rental house enforcement unit to go through a file? When the tenant comes to the rental house enforcement unit and files the complaint, how long more or less would that take?
So we do have internal benchmarks, but each case is certainly different, depending on the complexity of the case, depending on the offense. So the offense of, for example, failure to provide a rent receipt may not take the same length of time as withholding a vital service. There's certainly different there are different factors affecting that. It could take 30 days. It could be quicker because the landlord and the tenant both are in agreement, and maybe the landlord or the tenant were already in the process of working things out, and we just help to speed that up a little bit. Sometimes it takes a very long time. Sometimes it doesn't happen, hence why it may be referred on for further investigations, and then may result in prosecution activity, and that is subject to the timelines in the courts. We have no control over how long it takes to set these dates and schedule trials and such, but we try to resolve things as quickly as possible.
Thank you. Somebody else is asking, if the tenant would not leave the property after the sheriff leaves, should the landlord just call the police? Catherine?
So the sheriff will make sure that the tenants vacate. In the event that the tenants have left while the sheriff is there and then return, we hope that our landlords don't find themselves in that situation, but I would seek further advice and just also be careful for safety reasons.
Yes, and I think also just to add on to that, the locks would be changed. So once the sheriff is in attendance, the landlord should have their locksmith attend, or they do it themselves. The locks would be changed when the tenant returns. They technically should not be able to access the unit again because the locks have been changed. And I think a lot of the questions that are being asked now around the landlord's safety and concerns about the tenant not leaving, and the sheriff does work really closely with the police, and they come to keep the peace in these situations. If they have an idea that there's going to be an issue, they may contact the police ahead of time to meet them there. But the sheriff is not going to put the landlord or themselves in danger if the situation doesn't seem to be going well. So rest assured, you can always contact the police. You or the sheriff, you as a landlord or the sheriff can also contact the police if there's an issue at the time of the enforcement.
Thank you, Suzette. The next two questions are very similar. So how long does it take for the sheriff to act to evict the tenant? And the sheriff has scheduled a day for eviction. So how long does it take to evict the tenant, and is it a set scheduled day for eviction? Catherine?
Again, because sheriff's offices are run jurisdictionally, there's no set time. It doesn't take, a week or 2 weeks. It really depends on that particular office, how many other evictions are taking place, and the resources that they have. For this kind of second part of that question, no, there's no one set date that the eviction will take place. It's not like they only happen on Mondays or Tuesdays. The sheriff's office will keep the landlord apprised as to the specific date and time that the sheriff will be coming, because they'll have to facilitate being there for the lock change. But there's no way of saying that it's going to take this long, because jurisdictionally it's going to be different.
Thank you. Somebody's asking if they can post their landlord and tenant board order in a website, public website, for others to see that the tenant did not pay the rent. Maybe Suzette can answer that question.
I'm not aware that someone is allowed to do that. So I don't want to give incorrect information. You may want to seek some advice to make sure that you're allowed to do that. I don't know the answer to that question.
Like, maybe Catherine can answer that.
Yeah, I mean, there are websites out there that I know that this is happening. None of those, are associated with the Landlord Self-Help Center. Generally, our advice is to, avoid doing this because there is the question of if it's actually legal to do it or not. But yeah, again, we're not associated with those websites. So no further comment.
And as well, like PIPEDA protects the tenant's privacy. So most likely, yeah, it's not legal to do that, to share the tenant's information publicly. Somebody's asking if the sheriffs carry firearms or weapons. Probably not.
Yeah, I'm actually not sure. Suzette, do you know if they do or don't?
I don't believe they do. I don't believe they do. We can certainly find out, but I don't believe they do.
Okay. So somebody's asking, what if kids' names is not on the contract and stays in the house? All other kids' names, let's see. Yeah, so more or less the question is about kids staying in the property even though their names are not on the contract. So it's similar to what Suzette had already said, that the possession takes, it's about getting back possession of the entire property regardless of who's on the order, correct?
Yeah, so if the sheriff comes and they're enforcing an order, for example, and they see that kids are in the unit and they're under the age of majority, they're not going to say, hey, 12-year-old, get out. They're going to call somebody to report, to report that. If that is your question, if there are kids in the unit and the parents aren't home and they come to enforce the order, or is it the question that you have a lease and mom and dad's name are on the lease, but then son and daughter or whomever, their names are not on the lease? Is that what the question is?
Yeah, it's not very clear, but yeah, it could apply, to kids or roommates, other people that are not necessarily part of the lease. Would they be evicted as well?
Absolutely. Everybody who's at that address that they're coming to enforce an order at 123 Main Street, it doesn't matter who is in that dwelling at that time, the order will be enforced and everybody will have to leave.
Thank you. Somebody's asking, does the landlord need to be physically present during the 72 hours, or can they give the tenant a code to enter the unit between 8 a.m. and 8 p.m.?
I don't suggest you giving the tenant a code. If the tenant then refuses to leave after that 72 hours, you've already given them access to the unit. Have you started a new tenancy? I would be very careful about doing that. I would make sure that once you've changed the locks, I wouldn't give them a key to the new lock and have them show up and move as it's convenient for them. If you need to have someone meet them there, oversee that, that's what I would definitely suggest. Catherine, you may have something different to suggest, but I wouldn't give them a code to enter at their. I mean, I guess you could change the code again, but you're running into some issues. I would just allow them entry and then lock up when they leave.
Yeah, no, Suzette, I echo everything that you just said. I wouldn't, if I found myself in a situation where the tenants needed to come back, I wouldn't allow them access back to the property without, the landlord themselves or somebody working or helping the landlord be present at that time.
So one of the previous questions that we received is pertaining to fines for an illegal lockout. So what if a landlord does not wait for the sheriff to come and changes the locks himself or herself? What does that happen in that situation? So is that
If a tenant calls us to file that complaint, the act lists the maximum fines for an individual landlord, say $50,000. It's not, it's it doesn't mean that every time we go to court, we get that amount. It depends on the justice of the peace. It depends on the evidence that's presented will inform what that fine will be that's assessed at the end of the trial. So I can't say, okay, a legal lockout, it's going to be, 10,000 or it's going to be 5,000. We don't know. It depends on how egregious this offense, the facts leading to this offense, how it plays out and what we can prove and what the evidence is. So just know that the maximum fines are there, and you can be fined anywhere from 0 to that amount.
So somebody else is asking, can you enter the house after the log has been changed to make sure the water is not running and the stove is not on? And this question, I'm assuming, is being asked as a landlord.
Yes. So once the sheriff comes and the locks are changed, the unit is now, you'll have a certificate of vacant possession. The unit is now back to being yours. You can enter it as much or as little as you want. Certainly, I would recommend, making sure that everything in the unit is, not going to cause any issues like running water, the stove on, or that sort of thing.
Thank you. Somebody's making a comment saying if the landlord is not present, some tenants can attempt to change the locks back. I guess that was related to somebody giving out the code to the tenant. And somebody else is asking, does the owner stay in the house while while the tenants are removing their stuff, or should the landlord stay outside?
I would say up to the landlord, what you want to do. You might want to give them some space and some privacy. At the same time, you want to make sure that you want to make sure damages aren't being done at the time that the tenant is retrieving or removing their belongings from the unit. There's nothing in the act that says a landlord has to stay inside or outside of the unit. I would just, do what's fair. If it's raining, if it's snowing outside, you want to stand in the foyer, you just want to have a seat in the kitchen, or whatever. There's nothing preventing you from doing that. I would say as a landlord, my advice in this situation is just to do what makes sense for that particular case. If you and the tenant have a very contentious relationship, I don't know that standing and getting into a confrontation would be the wisest thing. So if you think you can stand quietly by while the tenant, do you have 4 hours to stand and wait while they're moving each and every single thing? I don't know, but I think it's in your best interest to be at the property if it's outside or inside while it's taking place, just to make sure that everything is safe.
Thank you. Do you have anything to add, Catherine?
No, again, I just echo everything that Suzette had to say. Whenever these things take place, there's always kind of some form of reasonableness that needs to be used. And if you don't know what's reasonable, you can always call us at the Landlord Self-Help Center or seek other legal advice.
Okay. Okay, so we're almost coming up to the end of our presentation, but I'll ask this question. It's to the Rental House Enforcement Unit. So are the orders and fines against landlords available publicly?
So convictions against corporations are posted on the Ontario newsroom. It does take a little bit of a search to find it, but our publication, we do publish the convictions against corporate landlords and also against individual landlords if they're what we call a repeat offender. So if you've been charged with the same offense more than once and convicted of the same offense more than once, and that's since like 2018, I believe, then the information is posted on the site.
Thank you so much, Suzette, for attending our presentation today. And thank you, Catherine, as well, for presenting on behalf of the Landlord Self-Help Center. We hope that our landlords learn lots of informative content today. And do you want to remind everyone about our survey, Catherine?
Yes. Before I get into the survey, I just want to say, Suzette, thank you very much for helping out with this presentation. Very valuable information. And thank you for everybody who participated and joined us today. We do offer a survey. There's a QR code that you can see on the screen. I'd really strongly encourage everyone to take time to fill out the survey because it helps us know, what we can do better for next time, gives you the option to discuss topics that you'd like to know of. So yeah, everybody, thank you very much. And again, please fill out the survey. It really helps us for further presentation.
Thank you, Suzette, and thank you everyone for attending. Until next year. Thank you.